Welcome back to the 2A Report. Prepare to be shocked by what a federal judge has recently stated in upholding a ban on so-called assault weapons. It is important to pay attention to this case as it has significant implications for gun owners across the country. It's important to keep in mind that although this particular case pertains to state-level matters, it involves a federal judge. As a result, this judge's decision could have far-reaching implications for other judges who share similar views. They may use the same line of argument to justify their rulings, even though it may seem unconventional. This case is called Delaware State Sportsmen's Association Inc. v. Delaware Department of Homeland Security. Judge Richard G. Andrews, a federal judge for the United States District Court for the District of Delaware, sided with Delaware's ban on so-called assault weapons and denied the motion for a preliminary injunction, a decision that carries significant weight not just for the state in question, but also for the entire country. It's important to be straightforward about what's happening here without any sugarcoating. As always, to give you a better idea of what the judge is saying, I'll rephrase the most important parts of the order in layman's terms for all you lawyer-speak haters out there. The focal point of the lawsuit is the claim that House Bill 450 infringes on the Second Amendment rights of the plaintiffs. However, the judge who presided over the case upheld the legislation and denied an injunction, sparking controversy and debate among gun rights advocates. Critics argue that the judge ignored key aspects of the Second Amendment, such as the right to bear arms for self-defense and protection against tyranny. Additionally, they claim that the judge failed to adequately consider the common use and military-grade status of the weapons in question, which would make them protected under the Second Amendment. While the judge's decision has caused concern among gun rights supporters, some legal experts believe that it will not hold up on appeal. They argue that the judge's reasoning is flawed and that any respectable judge who believes in the Constitution and the rights of the people would not uphold the ban. As the case moves forward, it remains to be seen whether the decision will be overturned on appeal or whether it will set a precedent for similar gun control legislation in other states. Despite the plaintiffs' claim that House Bill 450 infringes on their Second Amendment rights, the judges presiding over this case has a different perspective. It is worth noting that the judge's interpretation of the law could have far-reaching implications for gun rights across the country. The judge's ruling is particularly noteworthy because, on the one hand, he acknowledges that these so-called assault weapons are protected by the Constitution. On the other hand, the judge upheld the ban, claiming that the plaintiffs have not proven that their inability to possess or obtain such weapons for self-defense or other lawful purposes constitutes irreparable harm. In essence, the judge seems to be suggesting that while these weapons are indeed protected by the Second Amendment, their use is not absolutely necessary and that the ban can remain in place without violating the Constitution. The judge explains that the weapons in question are protected by the Constitution because they must be both dangerous and unusual to not be protected. This means that in order for the ban to be upheld, the weapons would have to be both dangerous and unusual, which the judge does not believe to be the case. Although the judge acknowledges that so-called assault weapons are indeed dangerous, he argues that they cannot be considered unusual because they are prevalent. Many people own them in large numbers, which means they are in common use. Therefore, they are constitutionally protected under the Second Amendment. However, despite this recognition, the judge ultimately upholds the ban on so-called assault weapons and large-capacity magazines. He bases his decision on the plaintiffs' failure to demonstrate irreparable harm caused by the ban. Specifically, the plaintiffs claim that the ban infringes on their Second Amendment rights to possess and obtain these firearms for self-defense and other lawful purposes. In the judge's opinion, the ban on assault-style weapons would not prevent the plaintiffs from defending themselves using other available means. He specifically points to handguns as an effective alternative for self-defense, noting that they are not regulated by the bill and are, in fact, the quintessential self-defense weapon. According to the judge, the plaintiffs have failed to provide evidence that they cannot adequately defend themselves without the banned weapons or that their ability to self-defense has been meaningfully diminished. Additionally, the judge argues that so-called assault weapons are not well-suited for self-defense purposes. Large-capacity magazines, he argues, are also not necessary for self-defense, as firearms can be operated using smaller magazines that provide the same effect. In the judge's view, the plaintiffs have not provided sufficient evidence to prove that their ability to defend themselves has been meaningfully diminished as a result of the ban. Therefore, he concludes that the ban does not constitute irreparable harm and defends its legality. In essence, the judge's ruling stated that although the weapons in question are safeguarded by the Constitution, the plaintiffs failed to demonstrate that they would experience irreparable harm due to the ban, as there are alternative means of self-defense available. Moreover, the plaintiffs could not provide evidence that in the absence of the prohibited firearms, they would not be able to use other lawful options to protect themselves. Despite violating their constitutional rights, the plaintiffs were unable to convince the judge that they would suffer irreparable harm if they were unable to use so-called assault weapons or magazines with a higher capacity. The judge pointed out that they still had other options available to them and that the effectiveness of these alternatives had not been proven to be significantly less. As a result, the judge decided to let the ban stay in place. Although this may oversimplify the matter, the judge's reasoning boils down to the idea that these weapons are not dangerous or unusual and are constitutionally protected, as they are commonly used for lawful purposes. However, the plaintiffs have not provided sufficient evidence to prove that these weapons are necessary for self-defense or that there are no viable alternatives available. To be honest though, I don't know what this judge is smoking. Following Bruin, the court is required to examine the text, history, and tradition regarding the Second Amendment. The first step is to determine whether the law violates the text of the Second Amendment. If it does, then that's the end of the inquiry. In this case, House Bill 450 clearly violates the text of the Second Amendment. Next, the court should consider the nation's history and tradition from the time of the Second Amendment's ratification in 1791 up to the Reconstruction era in the mid to late 1800s. However, this judge did not engage in this analysis. Instead, he stated that the ban was a response to a new advancement in technology. The judge in this case emphasized the importance of providing people with alternatives and not banning all options. He believes that as long as individuals have some options available to them, it satisfies the requirement of the Second Amendment. This argument, which has been used in the Delaware case, is likely to be heard in other states as well. It is a development that people should be aware of, as it may have significant implications for Second Amendment rights across the country. Despite the fact that these types of weapons are protected by the Constitution, the plaintiffs in this case were quote-unquote unable to provide irreparable harm, and the judge ultimately decided to let the ban stand. However, many legal experts believe that this decision will not hold up in the final ruling, as it goes against established precedent and the clear language of the Second Amendment. While there may be some activist judges like Richard G. Andrews who are willing to push their own agendas at the expense of our constitutional rights, there are some out there who are committed to upholding the law and protecting individual liberties and will not allow this type of infringement to stand. And while this may be a temporary setback for Second Amendment supporters, it is ultimately unlikely to have a lasting impact on the ongoing debate over gun control and firearm regulation in America. The situation is quite bewildering, and it raises the question: when did the Second Amendment's protection become limited only to self-defense? Are we ignoring the importance of defense against domestic and foreign tyranny? Allowing any kind of weapon ban to persist simply because there are other options available is a slippery slope that could result in us losing all of our rights. This type of argument could lead to a future where we can only buy single-shot rimfire guns. These judges ignore the concept of common use and overlook the Miller case, where it was ruled that a sawed-off shotgun was considered an NFA weapon because it lacked military use. It seems that some judges fail to recognize that semi-automatic weapons with standard use magazines are widely used by civilians and are also military-grade, serving as a means of protection for the country, state, and family from both foreign and domestic threats. It is essential that judges uphold the Second Amendment and take into consideration the common use and military-grade nature of these firearms when making their rulings. But what do you think? Is there hope for our friends and family living in Delaware? Is there a possibility that the state's House Bill 450 will be struck down? Let us know in the comments. If you like this type of content, please help our channel grow by clicking on the like, share, and subscribe buttons. And click on that notification bell so you're always updated of our future videos. Thanks and have a good one.